Catherine Baker, just testing. If you can hear me. Sasha?
Hear you.
I can hear you. Hi.
Oh, great. Hey, good morning. Nice
Morning.
to see you. Oh, wait, I don't have my video on. Okay. But I have roofers at my house while I'm taking this from the house, so it's gonna sound like somebody's digging for something on the top
Right.
of my head.
Well, it's good to see you. I'm gonna go back off for a little bit, but I'll
Me as well.
Okay.
All right, we'll see you in a bit.
Yeah.
Good morning. It is May 16th, 2024, and welcome to today's regular meeting of the Fair Political Practices Commission. Ms. Linker, will you please take roll?
Commissioner Baker,
Here.
Commissioner Ortiz. Here. Commissioner Wilson,
Here.
Commissioner Wood,
Here.
Chair Silver.
Here. Why don't we move on to item 1, and that's going to be public comment for items not on today's agenda. Do we have any public comment? Go ahead. Good morning.
Speaker, good morning. I came to your last meeting and I had some concerns, and in the meantime I got a reply to a complaint. And I have to ask, why are we here? Those of us in the public and those who supposedly enforce the law, why are we here? Aren't we both of us supposed to be making sure the intent of our laws, our codes, your requirements are followed? None of us are infallible. I just had a complaint addressed by your staff, the Assistant Chief of Enforcement. Attorneys win sometimes when they shouldn't. I would like to know how your appeal or how you appeal a decision, as I have seen nothing on your website, and it is difficult, if not impossible, to directly address staff who don't respond to email. Thinking about the appeal process, the case number was 2022-00756. And if you don't have an appeal process, I'm going to appeal directly to this board that you place this on a future agenda so they may speak to it, because I think the wrong decision has been made. Mr. Silver, I believe you told me the last time I addressed you that you couldn't discuss a specific case because your board might have to make a decision. I think your staff believes this case is over, so there should be no problem with me bringing my reasoning before you to show you what I would state is a problem. This case was about the city spending taxpayer dollars to promote a needed sales tax. They say it's a needed sales tax. I would not have had a problem if the city had done this before ballots were received and outside of the time people were allowed to vote. Your staff proffered the excuse that being that the measure failed, this was no problem. So this is akin to saying I take a gun and shoot at somebody and miss, so there's no problem. Even the assistant chief included the language from the ad watch portion of your website. Quote, when the style, tenor, and timing of the communication can be reasonably characterized as campaign material and not a fair representation of facts serving only for informational, end quote. Yet she failed to specifically address the aspect of timing in her response letter. As I stated, these 3 communications were done during the voting period. If that isn't timing, I don't know what is. The tenor is another item, and she stated the 3rd brochure came close. When you only give one side of the argument, you're advocating for a specific result. That's 2 and 3. Please tell me how you can attempt to scare voters during the election season and not claim that it meets these prohibitions. The intent of the law is to prevent city governments from advocating for ballot measures with citizens' tax dollars. You have now given the city of Dixon license to do the same thing again. If the sales tax increase that they're going to put on this ballot in November passes, can the FPPC overturn an election based on improper advertising? I don't think so. You may be able to fine the city, and guess whose money will be used to pay the fine? At this point, I am frustrated with the failure of this agency in recognizing the obvious. I don't know if you or any of your board members see these rejected complaints. Given the implications and enabling inactions of the FPPC, I still have to ask the question, why are we here? Thank you very much.
Yeah, and I appreciate you coming back today. Misuse of state resources, public resources in general for campaign purposes is a serious violation of the Political Reform Act, and something that our agency is focused on prosecuting. I don't know the specific facts. I haven't seen the advertisement that you're talking about, so I can't really speak to that, whether there was a violation there or not. In terms of whether there's an appeal process and the complaint review process, I'm going to defer to my chief of enforcement, James Lindsay. James, is there any sort of action, or Dave Bainbridge, general counsel, you want to step in as to what a complainant can do to seek appeal of the review of their complaint?
Sure. Complaints that are rejected by the enforcement division can be appealed to the executive director for reconsideration. I think it's regulation 18360 that lays out the options for making an appeal for reconsideration. Oh, this was a case, not a complaint. That's just for complaints. I guess this was a case. So there there isn't a mechanism for cases.
Okay. Well, go ahead.
I would like to get an address or an email address or something for the executive director so that I can correspond with him or set something up to appeal it. That's all I'm asking.
Sure. And just to clarify, so the general counsel just laid out there isn't an appeal process for cases. There's an appeal process for complaints. But I think it'd be helpful for you to connect with our executive director. She's right over there, Galena West. She can give you her contact information. And commissioners, any other comment on this item, on this matter? Commissioner Baker?
And just the distinction, cases is after it's been opened and it's been a declined or prosecution or closed versus a complaint that's rejected for future investigation is just clarifying the distinction between the two. Is that correct?
Ms.
Right.
West?
Galena West, Executive Director. That's correct. So a complaint, a referral, those are the things that come into enforcement that are processed and evaluated to decide if there's enough to open a case. So once a case is open, then the resolution is, as you all know, a no action letter, advisory letter, warning letter, stipulation or full prosecution or default. And in this case, it appears that the Enforcement Division thought there was enough to open the case. They opened it into a case, and then they closed it with an advisory letter, not finding a violation.
What's the difference
Thank you for the
between,
clarification.
for instance, just a general no action closure letter, an advisory letter, and a warning letter where a violation is found?
Sure. So a no action letter is generally when there's been either no violation found or something is out of the statute or there's reason to close something without doing anything about it. An advisory letter is more, I think that this entity needs to be advised that they were very close to the line and here's information for the future, putting them on notice. And then a warning letter is a violation has been found and it merits a warning letter under our regulation of the streamlined regulations that we passed, and it has the factors for when you get a warning letter.
It's helpful. Any other comment from commissioners? Okay. Moving on to any additional public comment? Okay, hearing and seeing none. Oh, we do. Okay, go ahead.
Yes, good morning. This is Steve Petzold in Santa Clarita. I'm on my way to the airport, so I can't stick around for number 5, but
Could you speak
certainly
up,
I was
Mr.
in-
Petzold? We're having trouble hearing you.
I hope you can hear me now. Can you hear me now?
Yeah, that's better.
Okay, I was very impressed by Mr. Bainbridge's comments at the Law and Legal meeting the other day. I think he put a lot of thought and time into whether members of CBOC should be able to be forced to file a conflict of interest form 700. I do appreciate the fact that he attempted to stay within the parameters of the Political Reform Act. So as he presents today, and unfortunately I can't stick around because I'm on my way to the airport, I just want you to consider that there's going to be billions of dollars worth of school bonds on the November ballot. And whether you decide they're subject to conflict of interest codes or whether you say that they aren't, I'm perfectly happy with getting an answer. I would just like clarity so that as we go into the fall, we can let the voters know that the citizens bond oversight committees are just paper tigers with no authority at all to do an oversight action. The whole word oversight, if they put this in the ballot language, if they put this in the ballot question, it gives a false sense of security to the people that their fellow citizens, their friends and neighbors in the community that are overlooking what these funds do, where these funds go, when the fact is that really they're just a potted plant or wallpaper on the walls. So when they have a conflict of interest policy for the CBOC and there's no way for the public to check out, whether there's any violations, where do they work, where does the spouse work? very basic information that should be available to the public, then we have no ability to follow whether the ethics policy is being followed. So I'm just going to close out today by saying that Mr. Bainbridge, in my opinion, did an excellent job, and I'm a strict constitutionalist. So if he's saying I'm walking the line here to stay inside the lines of the Political Reform Act, I accept that. But certainly, I would like clarity as to what CBOCs, what is the purpose of the CBOC, and when they put this stuff on the ballot, can the voters believe in it? So, a comment today. I've got to go, and I wish you all a good day. Bye-bye.
Thank you, and I agree. Mr. Bainbridge did an excellent job at the Law and Policy meeting, explaining the different rules that apply under those circumstances. And hopefully you get a chance to watch his presentation today, and that'll answer many of the questions that you have in that area. So any other public comment? Looks like we have some. Go ahead.
My name is James Rowan, and I spoke last month. One thing I'd like to remind the Fair Political Practices Commission about is that the Pittsburgh Steelers are the only NFL team to actually register political contributions in a political action committee. The San Francisco 49ers, since 2016, have excelled in dark money. As you know, dark money is a constant irritant to political reforms. Since 2016, the San Francisco 49ers have contributed over $9 million in dark money in Santa Clara City. Over 10,000 times more political contributions in Santa Clara have been done by the 49ers than any other person in the over 170-year history of Santa Clara. In 2024, the San Francisco 49ers have already announced that through their group, Santa Clara Now, which is being investigated by the Fair Political Practices, they will spend up to $1 million to try to re-elect Suds Jane, the person that began the secret meetings with the 49ers that led to the indictment of the person that they spent $5 million trying to elect as mayor. Jed York has been probably the most corrupt political operative of NFL history. The Political Practice Commission really needs to get a handle on it. If you recall the history of the Fair Political Practice Commission, even Kevin Sloat, the lobbyist for the 49ers, was fined the highest of any lobbyist in the history of the state of California. I've asked, and members of the public have asked, the Fair Political Practice Commission to get hold of Jed York and get a hold of Santa Clara Now and have action. Our city is not for sale. Thank you.
Thank you for your public comment. Any additional comment? No? Okay. Hearing and seeing none. Why don't we move on to our next item, and that's going to be approval of the April meeting minutes. Any suggested edits to those minutes, commissioners?
Move to approve.
Excellent.
Second.
Sasha?
Commissioner Baker,
Aye.
Commissioner Ortiz.
Aye.
Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Silver.
Aye.
The motion passes.
Okay, now we're going to move on to our consent calendar, which just has one item today, just to clarify, and that's going to be the adoption of proposed amendments to Regulation 18227.5. Does any commissioners wish to pull that item from the consent calendar for discussion? Doesn't look like it. Public comment on the consent calendar? Hearing and seeing none. Ms. Linker?
And calendar.
Second. Ms. Linker?
Commissioner Baker,
Aye.
Commissioner Ortiz,
Yes.
Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Silver.
Aye.
The motion passes.
Excellent. Okay, let's move on to item 4. I have a couple questions on this item for Chief Enforcement Lindsay, so we'll give him a second to come up here. Good morning, Chief Lindsay. How's it going?
Good morning, Mr. Chair and Commissioners. It's going well. How about for you?
Not too bad.
Good.
So this is the first pre-notice default I've seen on an agenda since I've been chair. I was hoping you could quickly summarize that process and give us whatever background that you can on this specific case.
Absolutely. This process is not required by our regulations. We do this and basically to try as a one last ditch effort after significant attempts to get a respondent to respond to us and hopefully come to a different resolution on the merits versus one by default. In this instance, the process seems to have at least potentially worked a little bit because we have had some communication with the respondent suddenly in the last 24 hours, which leads to your second question, which is that we probably can't disclose a whole lot about the specifics of the case because it might actually come back in a merits scenario. So.
Okay. Well, that's helpful. Then I'll hold any questions that I had related to that case to when it comes back on the agenda. Any comment from commissioners? Okay. Any public comment on this item? Hearing and seeing none, I believe we're going to move forward. We don't need a vote on this item because it's pre-notice. So we're going to move on to our general items, and we're going to start with the Conflict of Interest Code presentation by our General Counsel, Dave Bainbridge, and our Assistant General Counsel, Zuki Barar. Welcome.
Good morning. Our presentation this morning is going to be about conflict of interest codes and conflicts and who has to be named in a conflict of interest code and all those sort of things. We've had questions from a few different sources recently, so we thought it'd be good to give the commission and the public an understanding of how this process works. So I'm going to go over some of the basics of conflict of interest codes, the drafting of them, the adoption process, the process for amending, what is covered in a conflict of interest code, who is covered by a conflict of interest code, and then Suki's going to speak to the FPPC's role in conflict of interest codes because we are a code reviewing body, and so she heads up the unit that does the code review for state and multi-county agencies that submit their codes to us. And then we'll talk about the process for people who would like to challenge a code to potentially get it amended if they believe it is improper. And then we'll also talk about some of the recent issues that have been brought to the Commission's attention over the last few months regarding these issues. We're not going to speak to any specific scenarios, but we'll generally speak about the law in these areas and hopefully give some information to everybody so that they maybe better understand some of these issues. But again, we're not speaking to specific situations, just to the law in general, as Mr. Petzel has already mentioned, and we did at Law and Policy. We'll be focused on what the law says and not how things are operating from a practical standpoint for any particular agency. Okay. There's two basic things that a conflict of interest code does. It identifies who at the agency is required to file a statement of economic interest, and then it also identifies what those financial interests are that need to be disclosed. Not every financial interest of an official has to be disclosed. It depends on the official's status and their job duties and when they could potentially influence a decision that would affect them financially. Not all public officials file conflict of interest codes, only those who would have a reasonable likelihood of influencing their own financial situation through official decisions. There are two categories of SEI filers, which is important because it dictates what they have to report. We have what we call statutory filers, also known as Section 87-200 filers. These are public officials who are identified specifically in statute as being required to file SEIs. These are state-level legislators, city council members, county supervisors, those sorts of positions. All of those within the state are required to file and typically disclose all financial interests that are required by the law. The other category, which makes up the majority of people who file SEIs, are what are called code filers. They're found in Section 87-300 of the Act. They're defined as any officer, employee, member, or consultant that is designated in the agency's conflict of interest code. They're referred to as designated employees. So these are people named in the code as being required to file an SCI. Okay, so who is a designated employee? Each agency is tasked with deciding who within their agency should be designated as filing an SEI. And the standard for that is whether the public official makes governmental decisions or participates in governmental decisions by providing advice, information, opinion, or recommendations for the purpose of effecting a decision without significant intervening substantive review. So if a position doesn't either make governmental decisions themselves or have influence over governmental decisions being made by their agency, they will not be required to file a statement of economic interest. And when you look at it, the definition of makes and participates are both here, but makes is really the ability to take some sort of action on behalf of the government agency, and the participating is advising for the purpose of effecting actions that would be taken by other officials within the law. All right, we'll talk a little now about the code adoption process. Each agency must adopt a conflict of interest code. They're required by law. The conflict of interest codes are adopted by the agency itself. The statute states, you see the language here, that the conflict of interest code shall be formulated at the most decentralized level possible, meaning at the agency level, without precluding interdepartmental review. So the agency adopts the code, and there is a code reviewing body who reviews it for sufficiency. System is designed this way with the expectation that the agency is in the best position to know what the duties of their employees will be and who they think should be identified as someone who will have the authority within the agency to make decisions or participate in decisions that could influence their own financial situation. When a code is adopted or amended, there's a notice and opportunity to comment by the public or members of the agency. State agencies follow the traditional Administrative Procedures Act process. So the same way that we publish our regulations that are being proposed for adopted is how codes are handled. And then at the local level, they have to have their own process that allows for notice to the public and opportunity for public comment about the contents of a conflict of interest code. There's certain provisions within a conflict of interest code that is required. They have to identify the designated employees. That's probably the most important provision. They have to list the types of interests that each employee is required to disclose. Again, not every employee needs to disclose every type of interest. It's the type of interests that have been identified that they could potentially impact based on what their job description is. So you could have someone who maybe is in charge of purchasing for an agency of supplies or equipment or something. They wouldn't necessarily need to disclose real property interests because based on their job duties, they're not going to have an ability to influence real property interests they may have, but they may have to disclose income from certain sectors where they could potentially, through their job duties, influence their own financial situation in some way.
Substantive question. I can't see Commissioners Bigger or Wood on the screen. So are you going to be able to, Ms. Linker, flag whether they have any questions? Okay, excellent. Just wanted to make sure they could chime in. And then one quick question. Who makes the determination as to whether a body is an agency and has to adopt one of these codes?
I don't know. Do you know the answer to that, Suki?
That is determined by the agency and the code reviewing body.
Thank you.
And
Bigger?
Mr. Chair.
Go ahead.
Thank you, Mr. Chair. Since we paused for a moment, on the slide that had the definition of designated employee, which I think is one slide prior, maybe one more, Apologize. Thank you. Almost get us too far ahead. The very last bullet point looks to me, and we covered this in law and policy, but it's in the statute that if it's an unpaid board or commission that serves solely advisory function, they're not subject to these a designated employee status, and that's in the statute. That's not regulation. So if anybody wanted to have that changed, it would have to be changed in law. Is that correct?
Yeah, that's correct. Thank you for pointing that out. I missed that last bullet on that slide. That is a statutory exception. A designated employee does not include unsalaried members of a board or commission, where the board or commission has just solely an advisory function.
Okay, thank you. And I just point that out because that's kind of come up, particularly in law and policy, and the question about oversight boards that may just have a purely advisory as well as unpaid function. So thank you very much.
Yeah, thank you for pointing that out. I did miss that one.
Permanent word is, where is it? It is solely. Is that a determinative word? Solely an advisory function.
Right. Yeah, they would only be advisory. Okay, and then the last required, I think I talked about all these except, the code obviously has to require that SEIs be filed by the designated employees. And then there also has to include a recusal provision that explains to officials how they would need to recuse themselves if they did have a conflict of interest. The FPPC has a model code that we've adopted in regulation that agencies can adopt by reference. That's pretty common that an agency will just adopt the basic provisions, sort of boilerplate provisions that we have in our model code and regulation. But they still would then need to designate those employee positions and identify what category of financial interest the positions would need to file. So that really is the meat of the conflict of interest code. The rest is mostly just boilerplate. I think this is where we hand it over? Is this your first slide? Not yet? Okay, I'm trying. So the code review process, each agency has to submit a draft code to what is called its code reviewing body. The code reviewing body is designated by statute, and it depends on what the agency is as to who their code reviewing body is. For example, the FPPC is the code reviewing body for all state agencies and multi-county agencies. Typically for county agencies, it's the Board of Supervisors of that county. For city agencies, it's typically the city itself. So there are a few grounds under which the code reviewing body, once it receives a draft code, would reject the code. Oh, I'm sorry, I skipped over an important part. I suffered a head trauma this morning on the way here, so I'm struggling a little bit. The code reviewing body has three options once it gets a code to review. It can approve the code, it can revise the code itself and then approve it, or it can return the code to the agency to make revisions and then resubmit the code to the code reviewing body to look at again. So that's the role of the code reviewing body. As we had discussed earlier, the agency creates it. This is that intra-agency review portion of the process that the statute speaks to. So the grounds under which a code reviewing body could reject the code are here. These are the statutory grounds. One is under disclosure. The first one, if it fails to provide a reasonable assurance that the foreseeable conflicts of interest will be disclosed. The second is if the code is unclear in some way, it's a grounds for rejecting code. And then the last one is if the positions in the code or the disclosure requirements in the code are not properly tailored to the position and what the duties are of that official's position. In addition to the statutory requirements that are in the Act, there's also been case law, even prior to the Act existing, that found that public officials have a privacy right in their own finances, and that any requirements that they disclose their financial interests has to have a connection to their position and their ability to actually impact through official agency decisions their own financial situation. So we have a case here that from this California Supreme Court, Carmel by the Sea v. Young, that lays out this the balancing that needs to be done, that public officials don't lose their right to privacy just because they have taken on a public position. So you really, in requiring agencies, when agencies requiring officials to file, they need to take into consideration really what decisions can this official impact. I think the instinct sometimes is just to require disclosure of everything that needs to be required under the Act. Agencies really need to look more closely and make a determination of whether the person could actually influence their own financial interest in deciding what interests need to be disclosed.
Mr. Bainbridge, is there an example that comes to mind of an overbroad disclosure requirement that was imposed on a public official?
Nothing comes to mind that has actually happened, but I earlier I'd given the example of people who have no role in real property being required to disclose their ownership of real property interests. So I don't. So do you have any other examples in mind?
I'll just add that sometimes when we're reviewing the codes for the agencies, they'll submit a draft code to us, and we'll look at the categories and we'll work with them on what positions are included and required to disclose under that category. And a lot of times we'll see a little bit of overbroad disclosure there in the draft, but we'll work with them to correct it before it's finalized.
Good example from this case as well, right? The public official who challenged the code in Carmel, I think the jurisdiction was requiring that they disclose all of their financial interests on there, and it was eventually overturned.
Yeah, the law that was overturned in this case was any financial interest valued at over $10,000, regardless of their position. So, if they had $20,000 in the bank, they can't influence cash that's in the bank through a governmental decision, but they would still have to disclose that sort of financial interest under the old law, which was struck down.
Great, thank you. Commissioner Ortiz?
Yeah, thank you. So am I correct to understand that agencies have the flexibility to add more people as designated employees and to add more to the financial interests required to be disclosed?
Yeah, that is correct. In fact, they're required to do that. If they add a new position and that position, they can foresee it having the ability to make decisions that would influence their own finances, they're required to amend their code to include that position.
So if they do add, like you're saying, do they have to check with the FPPC to like the new position you're talking that to see that they are going down the correct path?
They have to check with their code reviewing body.
Mm-hmm.
Typically, they'll draft an amendment to the code and then submit it to the code reviewing body. So if it's a state agency, yes, they would submit it to us for us to review. So
Local agencies.
Local agencies go to their code reviewing body, which is usually the county or the city.
Okay, thank you.
And then another thing to note, and we're going to talk about this later in the presentation, I believe, is there's a biannual review that each agency has to conduct of its conflict of interest code to make sure there aren't any employees who should be included in their conflict of interest code.
In addition to. Oh.
Correct, yeah. Unfortunately, I was in charge of doing that review for the assembly, so I'm all too familiar with all of these rules. Any other questions from commissioners before we move forward? Okay.
We are rolling into the question that Commissioner Ortiz just asked, that agencies do grow and change over time, so they are required when that happens to amend their code. When they amend the code due to changed circumstances, they have 90 days to send it to the code reviewing body. And then they also have the biannual review that the chair just mentioned as well. Okay, now I think it's Suki's turn.
I'm going to talk a little bit about the actual code review process we do here at the FPPC. So the FPPC is I just want to make sure everyone can hear me. The FPPC is the code reviewing body for state agencies and multi-county agencies. And agencies, like Dave mentioned, at the very least are required to review their conflict of interest code every 2 years. And for the ones that we're the code reviewing body for, they're required to inform us if there's an update that is needed or not. And how we go about doing that is we send out what's called a biennial notice. And on this slide is an example of the 2023 state agency biennial notice. And so these go out for state agencies. We send them out in odd numbered years. We send them out in January, and they are due back to us in March. And on there, the agency needs to mark if they need an amendment, and also they also need to mark when they don't need an amendment. So this allows us to make sure that the agencies that we're the code reviewing body for are doing this check. And so for even number years, we send them out to the multi-county agencies. So it's every 2 years, and we alternate years, and locals also do them in even numbered years as well. Okay.
Is there any sort of oversight for local code reviewing bodies? Do we audit their analyses just to make sure that they are including the correct amount of designated employees, that they're complying with the requirements?
I don't know that we actually do an audit. However, if the employees have a problem with their code, there is a process for them to appeal to their code reviewing bodies. And then if the code reviewing body rejects their appeal, then we can review it. Also, agencies can reach out to us for advice. Local agencies can reach out to us for advice on how to amend their code and if their categories are appropriate as well.
Commissioner Wilson?
Yes, you've clearly laid out the process. Can you recall, generally speaking, how often does that occur, for the obvious reasons that if you're at the local level and you're an employee and you file a complaint, there are a whole host of issues that could come into play, retaliation, et cetera. Have you seen situations where employees have actually filed a complaint?
Yes, I actually have. We don't see it often, but I can tell you recently I've seen 2 in the last month or so. Okay, and so on this slide, just describing how many agencies we are the code reviewing body for. Right now in our system, we have 692 multi-county agencies that we're the code reviewing body for, and 224 state agencies that we're the code reviewing body for. And we currently have about 70 in process for multi-county agencies that we're reviewing, and 75 for state agencies. So when updates are needed, so usually when we get that biennial notice back and it says that they need updates, we'll begin the collaborative process with the agencies to start the update. And what we'll ask for, first of all, we'll provide them resources detailing what is required in a code. We have an extensive amount of information on our website, and we have other documents that we provide them that we have as well. We request a draft code from them, so showing the amendments that they're wishing to do. And we also ask for other documentation, including organizational charts for the agency, duty statements, and reasonings for why the positions are being changed in this latest update. And we collaboratively with the agency determine if the positions are properly listed and the changes are proper. The next slide. And so some of the questions that we ask when we're looking at this draft code that we get, we ask, are the positions in the code the type that normally do not make or participate in making governmental decisions? If they look like they're typically a type of position that doesn't, then we'll ask for more information from the agencies, such as job duties, and ask them questions about the type of decisions these positions make. And then we'll make recommendations on whether or not they really should be excluded or not. And then we also ask if they're, we'll look at the organizational chart, and we'll see positions that, if we see positions that aren't included in the code that look like on the organizational chart they should be, that'll be another flag for us, and we'll ask more questions about those positions and what they do and work with the agency on that. And then we look for, is there anything else out of the ordinary? For example, if we see similar positions in different divisions of the agency, we want to see do they have similar disclosure levels? If they don't, then we want to ask more questions about that and about the duties to make sure they have the appropriate disclosure category assigned. Also, if something happens where a manager in the organizational chart has lower level of disclosure than someone they manage, that's another red flag to us. So we'll ask more questions about that to tailor those categories properly. And then on this slide, I have listed some links to resources that we use when we work with agencies. These are all on our website, and this presentation, I believe, is going to be posted on the agenda today, so people can access these links later if they would like to. But I'm going to go. Sasha, are you controlling the save? Dave, can you click on the first link on there, please? Oh, it's over there. Can we click on the first link under website, please?
It's all together. I just want to highlight how excellent the resources are that we have in this area and how good of a job your team does. Like
Thank
I
you.
said, I've worked in this specific area of reviewing conflict of interest codes, and it takes you all the way through step one to completion, and all the law and all the steps are laid out there really well. So you're all doing a great job.
Thank you. So on this slide, basically, are links to our main conflict of interest code website. And there we have all the information about what needs to be included in a conflict of interest code. Here's the website's up now. And it talks about the parts of a conflict of interest code. It has detailed information about disclosure categories. We have sample disclosure categories on that website. We have we have a document that has a step-by-step process of each step that needs to be done for the code to be amended. And then we also have informational webinars that people can watch for local and state to see exactly what they need to do to get that code amended.
All right, back to me. We will be putting this presentation up on the agenda. I don't think it has to be made ADA compliant, and then it'll be up on the agenda for anyone who would like to either access the presentation itself or to access those links that Suki had just shown us. Now that we understand a little bit of how the code adoption and review process works, the question then turns to, well, what do you do if someone disagrees with what a code says or an agency fails to adopt a code from the beginning? So there is a process laid out for either challenging a code that has not been adopted or for basically saying that a code needs to be amended in the statute. If an agency fails to timely file the code reviewing body can issue an order directing the agency to file. If the code reviewing body doesn't do that, they can then refer it to us and the FPPC, and we can issue an order or adopt a code for the agency in the situation where an agency hasn't adopted a code, although that has to be done in collaboration with the agency. So I think a lot of times when an agency doesn't adopt a code, or hasn't amended a code, they're being non-responsive. So if that's the case and we can't get the agency to adopt, there's also the option to go to the Superior Court to obtain relief. And the Superior Court has broad authority to issue orders compelling the adoption of a code or compelling amendments to a code. If a member of an agency or a member of the public within the jurisdiction of that agency believes that a code should be amended, for example, maybe a position has been added to the agency that they believe should be filing an SEI, there is a process by which the member of the agency or the member of the public can petition to amend the code. The petition goes to the agency first. I think if any of Commissioner Wood's students are listening right now, we're talking about exhausting the administrative remedies. First, they have to go through the agency and request that the change be made. The agency has time to respond, 90 days. If they do not get a response or the petitioner doesn't like the response that they receive, they can then go to the code reviewing body. The code reviewing body then has 90 days to take action or issue an order. And again, if the code reviewing body doesn't take action or the petitioner disagrees with the lack of action by the code reviewing body, then they can also take that to the Superior Court to obtain relief through a court order. So these are the avenues when a code, somebody believes a code is not properly designating an employee, it can also be a situation where maybe an employee's been designated and believes they shouldn't be. So it can work both ways, either adding someone to a code, removing them from a code, or modifying what their disclosure category would be. Okay, now that... Yep.
Oh, Mr. Chair.
Go ahead.
Thank you, Mr. Chair. It looks like you're about to talk about the Bond Oversight Committee. So before you do, just on this one, can you comment on how prevalent some of these challenges are, how frequently we've seen them, either challenging an agency for not adopting a code, how often that happens, or challenging the code itself for including or not including someone?
Yeah, I don't know how often it happens for agencies where we're not the code reviewing body. I know as the code reviewing body, it happens not very often. I think I've seen maybe just a few in the years I've been here. We typically, because of the code review process that we do, we work really closely with the agencies and hopefully can avoid having someone petition to amend a code through adopting a good code from the beginning, and through the biannual review where we are looking for positions that should be added to the code. So in our experience, it doesn't happen all that often. I can't speak to the local level because we typically don't see those.
Follow-up question to that. Do staff receive any notice of these remedies that they could petition to be removed? I assume they wouldn't petition to be added, but I guess they could. Are they notified at all?
Yes, staff is typically notified when an agency is going to be adopting a code. And there's the requirement that it be done in a public way and allow for public comment. And obviously, that would include people who work at the agency that are going to be designated in the code.
Thank you. That's helpful.
All right. Now we're going to go to a couple of the specific situations that I mentioned at the outset that have come up where we have received some public comment. The first one is the issue of the Citizens Bond Oversight Committee, and the question is whether a member of these committees would be required to file a statement of economic interest based on how these agencies are set up by statute. Again, I'm not speaking to any particular Bond Oversight Committee, but rather generally based on the statute that creates them. So a little background on the Bond Oversight Committees. Bond Oversight Committees were a thing created back in 2000 by Prop 39. Prop 39 lowered the voter approval percentage required to pass bonds for school districts from 2/3 down to 55%. Along with that came the requirement that a school district that wanted to sell bonds to build school facilities needed to create a bond oversight committee to review the expenditure of the bonds, the proceeds from the bonds. So the members of a Citizens Bond Oversight Committee are appointed by the governing board, typically the school district. They are not compensated. By statute, they have to include certain members representing certain groups, for example, the business community, senior citizens, parents, and then if it involves a community college district, it would also include a student at the district or at the school. There are some conflict of interest concerns or preventative measures built into the law itself. Members of the CBOCs cannot be district employees, officials, vendors, contractors, or consultants for the agency. And then also the statute states that the members of the CBOCs are subject to Section 1090 conflict prohibitions and incompatible activities restrictions. So they can't have a financial interest in the bond itself. The purpose of the CBOCs, as stated in statute, is that they will inform the public concerning the expenditure of bond revenues. Their role is to oversee how bond money is being spent and report back to the public on that. This was the trade-off for lowering the voter approval rate within the requirement in the law. In exchange, they created these bond oversight committees tasked with the job of overseeing how money is being spent and reporting that to the public.
Asking these technical questions, but you referenced the term uncompensated. Does that mean, obviously they don't get a salary, but if they received a per diem or some kind of stipend, does that fall under the category of compensated or uncompensated?
I will say the statute creating them provides that they'll be uncompensated. So I don't believe they receive a per diem either. It doesn't mention a per diem. It just requires that they be uncompensated. Yes, volunteer.
Okay. And then they're not required to obviously file any kind of Form 700s then?
Don't spoil the ending of this.
Okay.
That's
just
what
a
we're
question.
getting. That was the question before us of whether they, based on how their position is defined in statute, whether they needed to file a Form 700.
All right. Thank you.
So that's the general purpose as stated in statute for the bond oversight committees. And then here is the specific statute of what activities they may engage in. So you see it's receiving, reviewing, inspecting, and reporting to the public various things related to how bond money is being spent. And this is important if you remember the analysis of whether they are participating in governmental decisions and whether they are solely serving an advisory purpose, which would mean they are not designated employees and would not be filing an SEI. So we collected all this information about what the bond oversight committees do based on what the statute requires of them. And then in looking at that and then looking at the standard again for who is a designated employee, our determination was that based on their statutory duties, they would not qualify as a designated employee. They're not making any governmental decisions. They don't have any authority to make decisions on behalf of the government. We don't see that they have the ability to participate in government decisions because their reporting is to the public. They're not an entity that is required to provide advice to the agency that the agency then would act upon. Who are they advising and who are they providing information to? It's the public. And then to the exception that, or the definition of designated employee excluding those board members that are uncompensated that solely serve an advisory purpose. We believe they solely serve an advisory purpose. And that advisory purpose isn't even to the agency itself. It's actually to the public. So our determination in looking at how these agencies are created was that they would not be required to file Form 700s because they did not qualify as designated employees for those reasons stated. Now, what we're not considering here is whether a bond oversight committee in a particular jurisdiction may have additional duties. They may have a role that differs from the way it's described in the statute. In that circumstance, there could be circumstances where if they have additional duties, if they are actually advising the school districts as opposed to providing information to the public, they very well could meet the definition of a designated employee and be required to file an SEI. We can't make that determination based just on what's in the statute for individual agencies. That's a question that would really have to be considered by the agency itself and potentially a code reviewing body. Many of what our research found is that many of the bond oversight committees have actually been filing Form 700s, whether that was in an abundance of caution, whether they thought it was a good policy, even though it wasn't technically required, we don't know. But there are quite a few bond oversight committees that do file Form 700s. And that may be because they also have been given additional duties by the agency that they're overseeing. So I'm going to...
Commissioner Baker?
Thank you. Council Bainbridge was right mid-sentence, but perhaps he was going to pause for a question because I'm going to ask one. Going back to this description of the boards as not not making a decision. They're reporting to the public, and they're not really reporting to the governing board. And when I look at the prior slide that lists several of their duties, I think it's, there you go. Two of them say, I think it's item C and E, recommendations. Recommendations are being made. And I wonder if you could say a little bit more here, and fair disclosure, I did ask this in law and policy. I still care about it, is a distinction between making recommendations to the public and recommendations to the governing board, because that's a pretty fine line. And what is the basis? Is it statutory? Is it a judgment call that you're making? If you can address those points, because it goes to potentially whether or not a oversight committee is going to be filing Form 700s.
Yeah, I think if you go back one more slide to what their purpose is, the purpose is all about informing the public, advising the public. There's nothing in their overall purpose about advising or informing the district itself. So while they do use the term recommend, I think when you look at their overall purpose, it's to the public, to provide information to the public. It is not to provide information to the agency. So I also think when you look at the exception for what is or from the definition of designated employee, this specific statutory provision saying these are not designated employees, it fits squarely within that. They are uncompensated officials, and they have solely an advisory role. They have no ability to make governmental decisions. So I acknowledge that recommendation can sound like making or participating in a decision, but I think when you look at the fact that they don't have any authority to do anything other than advise the public, we ultimately concluded that they wouldn't fall within that portion of participating in a decision, even though it does say that they make these recommendations.
If I may, Mr. Chair, I think as a practical matter, thank you for that explanation. As a practical matter, just like what is in practice, it is difficult to see how making a recommendation to the public is not also making a recommendation to the governing body, which I guess, if you want to say they're a member of the public, they're getting the same, I imagine, report or whatever, maybe it happens at a committee hearing or something, very, very fine in practice. So my next question is it possible that whether they are governed by or considered designated employee is based on the facts specific in a particular district? If it turns out that a school district is effectively receiving that advice to the public as advice to the governing board, and they are perhaps rubber stamping it or acting on it, is there a case specific or fact specific analysis, or is it kind of here as we're looking at it based on paper? Here's what it looks like on paper.
Well, yeah, I think as I mentioned before, if they're operating in a way that is different from just what the statute says, it's possible that they could qualify as required to file an SCI. I think as it's written in the statute, they are solely advisory and they're voluntary. So I think they are specifically exempt from this idea of being a designated employee in statute. If in practice they have some role where their decisions or their recommendations are being rubber stamped by the school district, then yes, I think they could then qualify as being required to file an SCI.
Thank you. And I took that more to your prior comments is more to if a particular oversight board had they wrote it as giving them even more authority and less just based on the language here. For me, it's an extremely close call on this, because there's this idea of if the oversight board is going to make recommendations to the public, that's effectively also to the governing body. And perhaps they're on very small things and it's a minor part of what their oversight is, and perhaps other times it's a significant one. That's just my feedback on this, and thanks for answering the questions.
Thank you. Following Commissioner Baker kind of line of questioning. Local transit agencies, and I'm talking, for example, the Bay Area, Alameda, San Francisco, when they go to the ballot, they include part of the proposal to create this oversight board of the expenditures of that parcel tax or whatever. And they do come before the governing board and present their findings and all that stuff, questions. And the governing board usually provides a response to those criticism or whatever from that board. Is that a gray area? Because it's not mandated by statute. They're included in their ballot proposals. How does that play?
This is what we're talking about here are just the Citizens Bond Oversight Committees for school districts.
So
the answer may be different for other types of bond oversight committees.
yeah, I mean, because that's part now of every ballot proposal. So I'm curious about it, whether they, they're quite forceful.
Yeah, I think you do a similar analysis of one, what are their statutory duties and authorities, and then also in practice, how are they operating?
Thank you.
This sort of that dynamic, it applies across the board, right? If you have an employee who falls in a classification that wouldn't be considered a designated employee, right? Maybe an office assistant, right? They're not considered to be making or participating in governmental decisions. But then in practice, at their agency, they are doing that. They would be subject to filing a Form 700, just like any designated employee included in the Conflict of Interest Code. So this is something we have to look at. If we have an agency that's going beyond its statutory authority and its employees or officials are going beyond their authority, then they would be officials subject to Form 700 disclosure. But in general, if they're not making or participating in governmental decisions, if they are an advisory body based on statute, then they would not have to file. Is what I'm hearing here.
Yep. Yeah, that's exactly right. And it, it's why the process is the agency is the first line. They're the ones that should be identifying who has the ability to influence financial interests and naming those people. And then the second line is the code reviewing body, as Suki was explaining. They don't know every agency intimately, but they know sort of what are the red flags, what are the things we should look at, and some of the things she had mentioned where they may not know exactly every position and what they do, but they know if someone's manager is not filing one, but the person who's being managed by them is filing an SEI, that's something we need to look into more carefully.
Okay. And there was a distinction that Commissioner Baker was making between making recommendations to the public versus making a recommendation to a specific public agency. So if you have an advisory body and they're making recommendations to a public agency, would that render the officials on that body designated employees? Or would we further look at whether there's rubber stamping, substantive intervening review, other aspects? I guess what I'm asking is, in effect, if a advisory body is making a recommendation to an actual body, does that make them a 87-300 agency?
No, and that's the exception to the definition of designated employees. If they're uncompensated board and they're solely advisory, then they are not going to be required to file. But you could then look at whether they're solely advisory or whether they actually are participating or making decisions based on the way they're operating.
And for these boards, who's making that decision? Is it the local reviewing bodies? Is it the FPPC, or does it depend on whether they're multi-county or in a single county?
Well, it would be the agency first, and then it would be their code reviewing body. So you're talking about the school district specifically?
Correct. These citizen oversight?
Yeah, I believe most of them are county agencies, so their code reviewing body would be the county in which the district operates.
Okay, that's helpful. Any other questions, commissioners? Okay, you can go ahead, Mr. Bainbridge.
Okay, so that was the bond oversight committees. We're moving to another topic unless there's additional questions. and this is agency consultants. So the definition of public official within the Act includes consultants. A consultant is a contractor, so not an employee or elected official or appointed official, but rather someone who contracts with the agency that has the ability to either make governmental decisions on behalf of the agency or serves in a staff capacity and participates in making decisions or performs duties that are the same as someone within the agency who is a designated employee. So consultants then, if they meet that if a contractor meets the definition of a consultant, they are then a designated employee in addition to being a public official, which if they're a public official, that means they're subject to the conflict rules. And if they're a designated employee, it means they're required to file an SEI. So a specific example that's pretty common of where you have a contractor who qualifies as a consultant to the agency is the contract attorney scenario. A lot of cities, especially smaller ones and special districts and entities like that, don't have an in-house attorney, but rather they hire from a private firm an attorney to act as their city attorney or agency counsel. In those circumstances, it's pretty clear that they will qualify as consultants, which means that the private attorney working for the law firm then has to file an SEI and are subject to conflict of interest restrictions. Conversely, an attorney who's hired for a specific case or a particular matter may not qualify as a consultant based on their decision-making authority, whether they can make decisions or act in a staff capacity. When we're talking about a city attorney, even ones that are private attorneys, they're acting in a staff capacity and can be influencing decisions, which is why they're covered. But if you have an attorney who's hired to handle a specific litigation, for example, they very likely may not meet this criteria of acting in a staff capacity. In that situation, they're simply just vendors to the agency, and they provide services like any other vendor pursuant to the terms of their contract. And they would not be required to file an SEI, and they would not be subject to the conflict rules.
General Counsel Bainbridge, your overview on contract counsels was very clear. But there have been situations that have even come up at some of our prior hearings where you have a contract counsel who may work for multiple governmental entities. Would that be impacted in any way by your analysis?
I don't think that would impact the analysis because you're still looking at what their role is within that agency. So there are attorneys that I know that are counsel to multiple, say, water districts. They could qualify as a consultant to each of those water districts and have multiple public positions and have to file SEIs for each of those positions.
Question. Sasha, do we have, Ms. Linger, do we have I'll defer to, is it Commissioner Baker? Go ahead.
I apologize, I had a little trick getting off mute. I think it's correct also that those attorneys, while they may not have if they don't have to file a Form 700, if they're not considered a designated employee, they still have a professional fiduciary duty and duty of loyalty to the clients, so that their own personal interest can't be put above the client. I'm giving you a leading question here. Isn't that correct? Because I know you haven't mentioned that yet, perhaps you will, but that's something that we haven't previously raised.
Yeah, that's correct. They have ethical obligations outside of the Political Reform Act as attorneys and licensed by the bar.
So presumably if there's an attorney who is a contract attorney who for whatever reason isn't filing Form 700, isn't considered designated employee, and there are concerns that person is putting their own or their firms or potentially other clients' interests above the contracting client, that would there's a whole other potential avenue of challenging that or raising that issue, either with the bar or otherwise disqualification, otherwise, so that are just totally outside our realm. Something important to keep in mind.
Yeah, that's a great point. I don't touch on that in my presentation. I'm focused just on the Political Reform Act, but that is a very good point.
So to follow up on that, on a more practical point, so when we're working with agencies on preparing their conflict of interest codes, like you said, we get organizational charts, we get duty statements, all those items, so we can see whether specific employees qualify as designated employees. How do we handle consultants? Do agencies know that they have to flag independent contractors for us to do that analysis? To what extent are they going to provide us the duty statements for independent contractors is the question.
They do is in the code, there'll be a little asterisk with consultants, and then the head of the agency can tailor category to consultants depending on what work they're doing, and they will attach that category to their code. And so the consultant, if they do need to file, will file under that category.
That's helpful. And if a new consultant is hired by an agency, they'd have to do an amendment to their code. Is that correct?
They don't need to do an amendment. What they do is it's just a separate document because their code covers consultants, and then in the code it will say the head of the agency can determine what the category should be for consultants. And so they will draft that up, and then they will attach that with the code, but it's not an actual amendment to the code.
Thank you. All right, and then this last slide lists just one opinion that the commission gave many years ago, and then a couple of advice letters that are specific to the situation of the consultant being an attorney. And it's these line of advice letters and opinions is how you determine whether a particular contractor would be considered a consultant that would then have the filing requirements. So in essence, and this gets to the question of whether a person who is a consultant of an agency is going to have a conflict of interest in something that may benefit their law firm. So if you look at the second bullet, the first bullet is the Maloney opinion, sets up the basic rule. That one it involved a city engineer, not attorneys, but it set the basic premise that if a agency consultant is performing the duties within the contract that they entered into with the agency, payments that they receive based on that contract are not going to create a conflict. However, if they're providing work outside of what their contract calls for to the agency, they may then have a conflict of interest. So you look at the second bullet, it's the ECIS advice letter. And in that case, the contract attorney advised on litigation, and our advice was that this was okay because in that instance, the original contract between the attorney's firm and the city included providing litigation services as they came up. So the original contract contemplated that there may be litigation. So even though an attorney could be advising that the agency should go forward with litigation on a matter, if the contract already says part of what we will be providing is litigation services, this would not be considered a conflict of interest for that attorney or the attorney's firm. Again, because the contract anticipates that there could be these additional costs due to litigation. The last bullet there is a similar situation. You have construction counsel hired specifically to advise on construction and whether the agency should settle a case or go forward with litigation. And same analysis here. They looked at specifically in deciding this letter and advising on this letter whether the consultant was involved in many cases over time and advised the agency on many different instances, in which case they appeared to be more of like the city attorney type role where they would be a consultant, or whether it was a single case or sporadically a few cases, not over a set period of time, but just sort of every once in a while they were consulting with this person. In that instance, they do not appear to serve the role of agency counsel, and they would not be considered a consultant in that situation. And why that matters is a consultant then couldn't contract for subsequent services for their firm outside of what the original contract was. If the attorney is simply a vendor, they can then contract for future services without it being a conflict, because they're not considered a consultant to the agency. They would just then again be like any other vendor that would be contracting with the city. So those are the two of the advice letters. There's a few others that follow the same line of reasoning, but you're really looking at what the consultant or the contractor, what the nature of their services is, and do they perform the duties of an employee versus do they perform the duties of a vendor to the agency. And that is the last slide in our presentation. So if there's any additional questions, Suki and I can field them.
Do we have public comment on this item? Commissioner Wood, go ahead.
No, I didn't even have a question. I just wanted to thank you, because every time I started to come up with a question, the next slide would answer it. And Ms. Brar in particular, your your kind of examples of how you review the code, I thought were really fantastic. It made me think that it was kind of like the chair said, like it helps reduce the work on the commission, because it's so clear how you will be reviewing it. And so anyway, I just thought the whole presentation was fantastic. I appreciate your work on this.
Glad it was helpful.
Public comment? Hearing and seeing none. Why don't we move on to our next item? And that's going to be an update from our general counsel on the Levine Act, Section 84308, advice and educational efforts.
I think we skipped over number 6.
Oh, there you go. Okay, let's go to item number 6, adoption of proposed amendments to regulations 18237 and 18421.2, cryptocurrency reporting requirements. And it's going to be General Counsel Dave Bainbridge again.
Yes,
Come on up.
still me. Yeah. Valerie, who presented this 2 months ago at pre-notice, is on her honeymoon. So we're not going to make her show up and report on this while she's on her honeymoon. So I will try to fill in for her. Previously, 2 months ago, when we talked about this at pre-notice, she went through the history of the agency's regulations on cryptocurrency and provided a very good explanation of what cryptocurrency was and how it works. So I'm not planning on doing that today. It's all in the memo here. If anyone wants to look at it, I'm happy to answer questions to the extent I can about it. But I thought I'd just focus on the two amendments we're proposing here. The first one is codifying advice that we have been giving over the last couple years on the question of whether cryptocurrency has to be reported on a statement of economic interest. The determining factor for us in determining that the cryptocurrency does not need to be reported is that we don't believe it meets the definition of investment within the Act. Investments have to be reported on SEIs. But investment as used and defined in the Act is a lot narrower than the way the term is commonly used. Many things are considered an investment. However, under the Act, investment is defined as a security issued by a business entity. The definition goes on to further exclude a number of items that I think, if you ask anybody off the street, do you think this is an investment? They'd say yes, including mutual funds, government bonds, pension plans, trust funds. All of those items are excluded from the definition of investment. Given that, and given the fairly narrow definition of a security issued by a business entity, it was our determination that holding cryptocurrency is not an investment because a cryptocurrency is not a business entity. And based on that, there is nothing in the Act that would require disclosure if a public official owned cryptocurrency. So that's the advice we've been given. The regulation we're proposing for adoption today codifies that advice that SEIs would not include holdings in cryptocurrency. So I'll pause there before we go on to the next issue addressed in this regulation in case there's questions or comments.
Comment. I agree with legal division's analysis. I don't think cryptocurrency is going to be considered an investment under the statutory definition. But that said, I still think that within the purposes of the act, I think it would be a financial disclosure that could give rise to, at the very least, the appearance of a conflict of interest. So, as I've flagged for our legislative director, I think we may want to pursue legislation next session that would add cryptocurrency as an economic interest that would be disclosable on a Form 700 and could give rise to conflict of interest. Just to clarify, I'm in support of this regulation, this piece and the other piece as well. But I do think in the future we could pursue legislation on this issue. Any other comments from commissioners before we move forward? Commissioner
I do.
Baker?
Sorry.
Oh, Wood. Go ahead.
Yes, I just want to say I very much agree with that. I really like what the legal division has done here. I think it's really important to point out that we're going to be not disclosing something in the campaign finance world, because I think so much of the conversation in certain parts of our political world is about over disclosure and anonymity and things like that. And so here we're kind of restraining ourselves. But I do think in the Form 700 context, I totally agree with Chair Silver, like it could really give rise to a conflict. And so it would be good to pursue legislation.
Go ahead, Mr.
Okay,
Baker.
I'll move on to issue number 2. And this goes back to regulations we passed probably 2 or 3 years ago now at this point, regarding the acceptance of cryptocurrency as a campaign contribution. And just for those who weren't on the commission at that time, what the commission ultimately decided is that they wanted to permit contributions to be made in cryptocurrency. However, there were great concerns about the traceability and the anonymous nature of cryptocurrency beyond even that of cash. So in the regulation, although the commission said that contributions can be made in cryptocurrency, we had the requirement that contributions made in cryptocurrency be converted to US dollars through a payment processor before the money actually went to the committee that was receiving the contribution. So that's what the regulation has been for the last few years. In that regulation, we said that the contribution should be reported like a non-monetary contribution. With some hindsight, we've realized that that is not necessary because the cryptocurrency is being turned into US dollars before it goes to the committee. It's not necessary that it be identified as a non-monetary contribution. We think it should more properly be identified as a monetary contribution, which makes the reporting cleaner and easier. And there's no loss of disclosure. It's just being reported on a different portion of the campaign statement. So we're proposing to change our regulation so that contributions made via cryptocurrency that are then converted to US dollars before they go to the committee will be reported just like any other monetary contribution. So that is the second cryptocurrency related proposal, the second regulation you see here, and I'll take any questions on that one.
Thank you. No questions from commissioners. Do we have any public comment? Hearing and seeing none, do we have a motion?
Proposal, suggestion proposals.
Why don't we clarify the motion to adopt item 6?
Regulation 18237, 18412.
Perfect. Do we have a second? Excellent. Ms. Linger?
Commissioner Baker,
Aye.
Commissioner Ortiz, Commissioner Wilson, Commissioner Wood,
Aye.
Chair Silver.
Aye.
The motion passes.
Okay, so I know that one of the other commissioners has a time conflict coming up. So I'm wondering if we might be able to kick the legislative update in front of the 84308 update. Any thoughts on that? I know our legislative counsel is not in here right now. You'll go quick?
Yeah.
Okay. Excellent. Okay, then let's.
It's the day.
We'll hold you to that. Let's move on to item number 7. Update on section 84308, Levine Act, advice and educational efforts of General Counsel Dave Bainbridge. Thank you.
Yeah, I don't have anything to add to what's in the memo. Just to remind the commission, I've been asked to bring back periodic updates on how things are going with pay-to-play and Section 84308. So we've got the advice letters that were given into last year and then the first 3 months of this year. We've got some email advice that has been given, and then we've also got a list of the training that has been done since the prior update that I gave, which was in October of last year. So this is the update. If there's any questions, I'm happy to answer of them. This memo goes on our website under our 84308 pay-to-play page. So if anyone's interested in reviewing these memos, we're posting them there, and you can go and see each one. And it was supposed to be quarterly. I missed my quarter by about a month or two, but we'll do them periodically, the updates as we have enough information to fill them.
Thank you, Mr. Bainbridge. And before I throw it over to Commissioner Baker, I just want to note what could arguably be an ex parte communication here. Executive Director West, General Counsel Bainbridge, and our Legislative Counsel Lindsay Nakano, myself, we met with the Civil Prosecutors Coalition yesterday, which included representatives of the City of San Francisco, San Diego, Oakland, San Jose, and Santa Clara to discuss Section 84308, to discuss legislation related to it, and then to discuss the efforts that we're making to assist them in advising their clients. And I can tell you that they're very satisfied and grateful with all the work that we're doing on this. So excellent job, Mr. Bainbridge and your legal division. I know they're very appreciative of the frequency that we're putting out all this advice, whether via email or an advice letter. So thank you again. Commissioner Baker.
Thank you. I second your feedback. And also just wanted to ask, during the original adoption of implementing regulations, and I think in some of the follow-up after, the topic of strong mayor, how things are working out in strong mayor cities came up. I see from the memo, there's no particular in-depth mention of that. Are there any other either developments or updates on the strong mayor questions that had originally arisen during adoption that vexed us? Or do you feel like the feedback you've received, things are going smoothly in that regard?
Yeah, we issued an advice letter last year regarding the question of strong mayors. Since then, I haven't heard anything. My sense is that provided them the guidance they needed. It's not a one-size-fits-all rule, because what is a strong mayor in one situation, it can be defined differently by each ordinance for each local jurisdiction. So we only had one question from one particular mayor, but I think the principles laid out in that letter seem to be instructive, because I haven't heard they weren't. So I would assume I would if that issue was still out there.
Great. Thank you for that update.
Other comments from commissioners on this item? Do we have any public comment? Okay. Hearing and seeing none, why don't we move on to our legislative update from Senior Legislative Counsel Lindsay Nakano. Good morning, Ms. Nakano. So I know today is suspense day. I don't know where we're at in that process, but I assume you'll have a lot of updates for us today.
The suspense hearings are ongoing, so I have a couple updates, but unfortunately not a full update. So there are 20 active FPPC-related bills. Added to this month's report are the Commission's costs for all of the bills. I'll go over that information and some other updates. As the Chair mentioned, the suspense hearings are today, so we'll be awaiting what happens to 6 or rather 5 PRA bills. I have updates on 2 of them. I'll go through those as I get to them in the report.
And we have some public commenters on 2 different bills. Perhaps we want to do those bills first. So in deference to our public commenters' time.
Absolutely, I can move to those. I believe the first that we have public comment on is SB 1170 by Senator Menjivar. This relates to the use of campaign funds for mental health expenses. We have been working with the author's office and sponsors on technical amendments. There was a comment letter attached to today's agenda that includes some of the amendments that the author is planning to accept. These changes include allowing the use of funds for mental health expenses also for candidates who are incumbents, allowing the use of funds for a person who wins the election until the candidate is sworn into office instead of when the election results are certified, altering the language relating to health care to provide that the funds are available if insurance doesn't cover mental health treatment, providing that the candidate must report the need for the expenditure based on whether it fits into one or more categories, prejudice, harassment, or criminal threats or actions, and also defining those reporting categories. Providing that a person is not required to report on the instance of prejudice, harassment, or criminal threats or actions to law enforcement, and also some record-keeping requirements. That bill is on the Senate floor awaiting a vote, and I believe we do have some public comment.
Excellent. Do any commissioners, Commissioner Baker?
Thank you. Mine's a pretty nitpicky or clarifying question. On page 17 of your memo, where you're summarizing, I believe, this bill, the last paragraph that says mental health care expenses defined, the last sentence says, an associate accruing the house for such a license.
Hours. Apologies.
Oh, okay. I thought maybe that was, I figured that could be the case, but just if it was a term of art or what that might have meant. So somebody who's training to get their license, but they'd have to be in some type of hopefully accredited training program. It's not so easy to say I'm training to be an acupuncturist, for example, but not really in anything official. I just wanted to clarify that. Okay, thank you for that.
Ms. Nakano, quick question. So I know Commissioner Baker and I have hearkened on this specific item issue a couple times in law and policy now, that the act specifically prohibits use of campaign resources for health-related expenses. Have we in the past supported legislation that has amended a prohibition like that? Have we ever supported legislation that would eliminate a prohibition and actually allow for those types of campaign expenditures?
I believe the commission is supporting the bill this year relating to security expenses, and that relates to use of campaign funds. I don't know whether the commission has ever reversed a prohibition in the Political Reform Act in this way.
Okay, that's helpful. Any other comments from commissioners? Okay, I understand we have some public comment. You can come up to the dais. Chair Ravel.
Your detail. Push the button to speak. I am here asking for your support of the changes to the changes in SB 1170. And while I understand your question about has the commission ever done any amendments to those things, in this case, it is really important that the commission approve the issues relating to mental health that arise out of an elected official or someone who is a candidate for office, because that is something, and I know others can speak to this from Women's List, and they have some amazing materials that you could see about the percentage of women in particular, but others who have been subjected to harassment and other issues that give rise later, either for people who have had, it exacerbates.
My apologies for interrupting you.
Okay,
Commissioner
no problem.
Ortiz asked that you identify yourself and who you
I'm
represent.
sorry. I'm Ann Ravel, formerly a chair of the FPPC, and I am here to speak on behalf of this measure. As a former candidate myself, I could see why it is so important that the FPPC support those who do have mental health issues that arise because of the treatment that they receive during campaigns. So it is not similar to the question about healthcare. It is different because in this instance, it is absolutely something that is because of the political issue. And that is what the FPPC regulations require, as you know, that the expenditures of campaign funds have to be for legislative, governmental, and political purposes. And these are political purposes. And they are directly related to those purposes when people have to seek counseling or some other mental health assistance. It's not the same as healthcare generally. And as I know you've said also, the FPPC has determined that campaign funds can be used to pay, for example, for lawyers who used for lawyers in an action to halt defamation or defense of an action to halt defamation. And additionally, as I'm sure you all recognize, the FPPC has also allowed the use of campaign funds for childcare expenses that arise directly from engaging in campaign activities. This is no different. It is absolutely no different. And the issue about directly in those cases has been defined as meaning that the candidates would not have otherwise incurred for childcare, the childcare expenses, if not for the candidate engaging in campaign activities. And based on that decision, it's clear that mental health issues caused by the campaign and the need to get care for those issues for candidates is directly related to a political benefit and the activity of candidates. And it should be deemed by the commission to be clearly campaign related. And consequently, the law should reflect that mental health care for candidates who have faced, which many of them have, and if you see the booklet that was put together by the studies done by Women's List, many of them have faced hostility and harassment in the political campaign. And as they have said, and I don't want to reiterate because you're probably going to be able to read it, but they did a study with over 100 candidates for state or local offices in California since 2016, and it showed that 80% of the candidates developed new or exacerbated mental health crises and issues caused directly by this hostility that they faced in the campaign. So allowing them to use campaign funds for mental health expenses that are related to the campaign, understandably, that's the standard for the FPPC. It can allow them during the campaign to deal with the abuse that they experienced during the campaign. And so clearly, the costs incurred are campaign related. So the exclusion of health-related expenses that's contained now in the FPPC's, what the FPPC permits or does not permit, they are unrelated to a campaign. And so understandably, those health-related issues, just plain health-related issues of people who have had health issues previously, it is understandable that that's in the statute, but the statute needs to address what is really existing now with respect to mental health, which is very different from physical health issues. And that those, I guess, impacts of harassment and assault are clearly related, as I've said, to the campaign, and impacts to the candidates that are not negligible. They're very, very basic and meaningful. And as will be said possibly by others, often the people who are treated with hostility when campaigning and deal with adverse mental health impacts of that hostility and aggression and sometimes violence. Generally, the percentage is very high for women, people of color, and LGBTQ plus candidates who are most often in a position of being dealt with those issues. So I don't want to go on too long about these these matters, but I really do think that this is something that is important for the FPPC to concur with and to agree with this legislation that is specific, and it is absolutely incorporated already in the law relating to these matters. So thank you.
I just want to thank California Women's List for all the information they've provided us on this topic. It's comprehensive, it's excellent, and it's impressive. So thank you again.
Thank you. That's so good to hear that. I'm Marissa Roy, president of California Women's List, and I won't belabor the report too much since you all have it. The FPPC came up with, or the AG, I suppose, in the memo, came up with the rule that the distinction between personal and campaign-related expenses is whether something conferred a substantial personal benefit with negligible political, governmental, or legislative benefit. We're not going to argue here today that this doesn't have a personal benefit. What we are going to say is that the governmental benefit is not negligible. So the health-related exclusion was made when there wasn't an understanding of how mental health impacted on campaigns. What not just California Women's List, but the Brennan Center in a report a couple of months ago substantiated was that actually the hostility on campaigns and in government, but we'll focus on campaigns, impacts a candidate and then impacts their governance and their campaign decision making. These are campaign created liabilities that then have campaign results. And that's what makes them campaign expenses. What we have incorporated into how we've defined SB 1170 is that it's not a situation where if you had a pre-existing mental health condition and then had a campaign, you would be using the campaign to pay for your pre-existing mental health condition. It always has to be tied to a campaign-related source of hostility. So we've defined, taking Commissioner Ortiz feedback, 3 categories: prejudice, harassment, and criminal threats or criminal acts, diction. So a candidate would have to explain why any of the new mental health symptoms is related to something they've experienced on the campaign. It can be something that was pre-existing mental health disposition that was exacerbated, but there has to be a campaign-related source. That is what's going to keep this an incredibly narrow and politically focused exception and expenditure. We believe that we have the data to show that these certainly are campaign-related and campaign-created liabilities. We also believe that allowing these expenditures, and have talked to many candidates, would allow them to be able to not have to make decisions that are harming their campaigns, taking themselves off canvassing, taking themselves on mental health breaks for 2 weeks during intense campaign times. These are decisions that they're making because they haven't had access to any resources, because generally when they have to run, they're taking time off and don't have health coverage. So this is a narrow exception, very explicitly tied to the campaign with protected reporting categories, so no one has to be traumatized as if they are complying with transparency. I'm happy to answer any questions. I'm trying to speed as I see my time is out. But we hope we've addressed your concerns, and we hope we've also shown you why this very, very, very narrow limitation is justified.
Questions from commissioners? I have some quick questions. So you mentioned the advice from the Attorney General's office.
Yes.
Is that coming from the opinion that the statute was based on?
Yes, that's the opinion letter I was referencing. I think you all discussed it at your April meeting.
Excellent. Is there any way you'd be able to share that with our office so we could take a look at that?
I will admit that I was listening to your meeting about it. I was under the impression you already have that opinion, but I can go look for it if needed. maybe Ms. Nakano, do you already have it? Okay, I was going off your description. I can try to find it if necessary. I was quite honestly going off the description.
Excellent. I appreciate that. And then you mentioned that candidates would be forced to explain the basis for the expenditure, correct? I know Commissioner Ortiz expressed some concerns about that, about public disclosure. So what would be the process of a candidate explaining why the expenditure is justified?
So I'm going to actually take a pre-step too to remind everyone that this is, I think the word force is probably inapt here because it's always a choice. A candidate doesn't have to use these funds for mental health if they don't want to. If they're making that choice, because this expenditure is so important and the mental health related impacts of hostility they're facing is so severe that they can't focus on the campaign. Because otherwise, I think we all know candidates would rather be spending that on voter outreach. If they're making this decision, any campaign expense, we spoke last time, there's the overlapping need, but also need to comply with the Political Reform Act's needs for transparency. And so the way that it would go for reporting, the bill says that you are allowed to use campaign funds for mental health expenses that are arising from 3 campaign-related underlying circumstances: prejudice, harassment, and threats or criminal acts. And so on the reporting, you would just need to note which of the 3 categories that is, whether it's prejudice, whether it's harassment, whether it's criminal threat. There's no requirement that there has to be anything reported to a law enforcement agency. There's no requirement that any civil or criminal action needs to have been taken. And those terms are defined consistent. Criminal acts and threats is defined consistent with the penal code. Harassment is defined consistent with other statutes, kind of drawing from both criminal and employment. And prejudice is defined consistent with inspiration from the Unruh Act. So these are terms that are well known, defined in the Act, and that's all that would appear on the reporting. So to your concern, if anyone was ever taking those reports and trying to use them, I don't think that an opponent would get, frankly, much traction by trying to say, look, my opponent is using money because they're saying they were harassed. That actually might have the opposite effect and inspire some sympathy for it. So we believed this was a way to harmonize this commission's need for transparency, but also protect the candidate from having to go into any personal details that could lead to any exposure or trauma. And we also shopped these categories by candidates who have run to make sure that they were comfortable with this approach. And in many cases, not only were they comfortable, but they thought of it as something that could be empowering to help start the conversation. More and more women, especially who are experiencing this, are trying to come forward to call it out. And they've been doing so alone. So this commission's recognition that this is important, that these are campaign related, these are not personal or something they have to go through alone, actually helps legitimize their experience.
That's helpful. This is probably more of a question for Mr. Bainbridge or Ms. Nakano. If a candidate was audited after this law was adopted, what could the FTB look at to see whether this was a appropriate expenditure of campaign funds? Would it just be the explanation saying that this arose from prejudice, criminal threat, the other categories that were stated, or is there other documentation that FTB could review?
I believe that the documentation that is planned for the amendments would be things like the number of hours and the rate at which the person received the services, so the dollar amount and the total and how many hours they received. As for the reason why the mental health services were required, the campaign-related reason, there is nothing that I'm aware of in the language that would allow the FTB or another auditor to corroborate or verify the exact circumstances that led to this. And I think there's, as the commenter stated, there's some balancing factors about whether and to what extent a candidate should be required to disclose that kind of information.
Commissioner Ortiz?
Yes, thank you, since I'm the one who raised the issue before. The most important that I thought about after I left the meeting, and you mentioned, this is a choice by the candidate. That candidate assumes the risks, even though I still think that it might impact that candidate. But I understand the need to have that mental health, accessibility to mental health. But that, again, is the choice of the candidate.
Wilson?
I would say it's, at least in my opinion, that we should go on record in support of this legislation. I just checked the history, the bills on the Senate floor, and the attacks on female candidates, female elected officials going back decades is something that needs to be addressed. And I think that the legislature, as it debates this measure, can iron out some of the nuances that need to be addressed. But mental health is an important issue that needs to be addressed, and with social media being used as a tool to attack candidates, especially female candidates or women candidates, as well as candidates of color, is something that we should be mindful of. So thank you.
Thank you.
Those are really good points. I personally am not ready to take any position on the bill today because I want to better understand the technical aspects of it. I can tell you from practicing in this area that advising on the personal use rules can be very difficult, right? And in some cases, I imagine that a candidate would end up spending more money on paying an attorney to construe these rules than actually on mental health care. So I want to make sure that we flush this out, that the amendments are finalized before I'd support taking a position on this. But nonetheless, I think you make great points, and I think this topic is very important, and I think we all recognize that. Any other comments from commissioners? Commissioner Wood?
Yeah, I just wanted to thank everybody for their comments and say hi to Chair Ravel. I'm sorry I'm not there. And also just to agree with Commissioner Wilson that I would be perfectly willing to move ahead in support of this today. Thank you.
Commissioner Baker?
Thank you. And I thank not only Chair Ravel for the detailed comments, but also the sponsors or the major supporters, all the information that you've provided on this. And it really has got me thinking all along about what campaign funds should and should not be used for. Like the chair, I'm not prepared to support what's before us today. And for full disclosure, I'm still seeing a distinction between other expenses that this commission has supported, the security expenses, and it may have predated my time on the commission, the child care expenses and mental health expenses, not denying the need for access to mental health. Having been a woman candidate and as well as a person in office, I have plenty of on the receiving end of what we're concerned about here for sure. But I do see the distinction because the statute has specifically said that healthcare expenses are not to be covered by campaign funds. And I'm struggling a bit with, and that's why I'm disclosing this for future conversation, if that's helpful. So many have fought for mental health care to be treated in parity with what we may call other health care. So, and I think in Chair Ravel's comments, there was a sort of an argument that they're different and that mental health care should be treated differently in this setting. And for me, a campaign where you're going to have weight gain, your blood pressure could go up, the insomnia, and this is not insignificant. They could be physical manifestations that are not mental health care. And there's been a lot of effort to try to treat them the same. So I am sometimes mindful of the books, you give a mouse a cookie, all these other things are going to be taken along. And I'm not trying to minimize this, but once we do mental health care, how is that different than your heart condition, your blood pressure, your weight, cholesterol? How is that different than your car and gasoline that you're going to be expending to drive from campaign event to other campaign event, which I believe is not, I may have this wrong, but it's not something that you can pay for, mileage, for example, for the candidate. So I'm not there yet. I see a distinction between how the statute so specifically calls it out, and I'm grappling with how are we going to be treating mental health care differently here when so many have fought so long to treat them the same and give them parity in acceptance and in the healthcare world. And I also am mindful of it. Mental health care is important to have an professional. It's not the only way to have support. Organizations like those who are supporting this and ones that I'm involved in can be standing by women candidates, supporting them as they go through the challenges that come from running for office and being targeted by hostile treatment. And so I don't want us to see that this is the only way they're going to get support. I'd like to continue to see those efforts more robust. That's where I'm at on this right now. I'm not at the area where I'm comfortable having the FPP support this legislation. I have additional reasons why, but those are some coming to mind. Thank you for colleagues for hearing me out on that.
Thank you. And one additional item to keep in mind is, legislation is going to have to further the purposes of the act. And if it doesn't, then it could get struck down. And I have some concerns. That's why I asked the question that I asked about legislation that removes explicit prohibition in the act. How has that been handled in the past? I'm concerned that we could go through all this work and then it could just get struck down by the court as not furthering the act's purpose. So go ahead.
Yeah, I was going to ask if you would like a response to that. I think, and I'll let former Chair Ravel speak as well to maybe some of her comments. I think that what I would ask this commission to focus on is, I'm going to sound like a statutory interpretation nerd, but I think we also need to look to the purpose. So Commissioner Baker, you bring up healthcare expenses and this idea of treating mental health care and healthcare is different. I would reframe it to say we're going actually back to the rule that underlied all of the separation between personal and political, which is this rule of, is it substantial personal benefit with negligible political, legislative, or governmental? Before we had all of this data, there might have been no reason to make this narrow carve out. What we're actually learning now is that, as the report mentioned, there is this cycle where campaign hostility that's experienced by over 50% of candidates is causing 80% or more of them to experience mental health symptoms. These mental health symptoms that are not just internalized by the candidate, they're affecting campaign decision making in nearly 50% of women, which is what we focused on. But I'm sure, of course, LGBTQ and people of color, men of color as well. So these are campaign created liabilities, and we now have data to back that up. So this isn't asking for a carve out or to treat things as different. It's actually asking to clarify, to make sure that we're actually consistent with the rule that was established that was supposed to guide that distinction between campaign related and personal. With this new information and this new data, what we're learning is that these campaign created mental health impacts have campaign impacts, which is why they have much more than they have a pretty substantial personal, but also political, governmental, and legislative benefit. It's also why we've defined it very narrowly to not say all mental health expenses, just the mental health expenses that are tied to hostilities that come up on the campaign trail. I understand, of course, there's always the slippery slope argument, but I think as long as this commission stays by the rule of substantial personal benefit with more than negligible political, governmental, or legislative, I think that's how they would stave off that slippery slope. This exception has more data behind it, frankly, than the child care exception that was made. I'm totally in favor of that, not to speak down on it, but I think we knew that this bill, because it would be asking for an amendment, would have to be extraordinarily data backed, not just by us, but as I mentioned, by the Brennan Center, who has taken a position in support of this bill, by the Princeton University Bridging Divides initiative that first kind of brought to light these instances of campaign hostility, by the San Diego University's publication as well. We can provide you more reports if you want to read more than just ours, but this is extraordinarily data backed, and the clarification we're asking in SB 1170 is again very narrow, so that it won't be all mental health expenses. We're trying to avoid the slippery slope just as much as you are, Commissioner Baker, but really will be campaign related. So we're not trying to treat things as different. We're actually trying to be much more in line with the rule that made the original distinction. Now that new data has come to show that that distinction might not be being applied right now in the ways that best further the act. We think that at the end of the day, this does further the act, not just because of the data, but also the act's interest in allowing for transparency, but also allowing for more representation, more people, instead of letting dark money affect our systems, dark political practices affect our systems, allowing people of color, women, LGBTQ members who have been less represented in government, giving them a chance. And part of giving them that chance is also giving them the resources and the choice so that they can fight all of the obstacles they face, which aren't just fundraising gaps. Often, frankly, the biggest barriers are these invisible barriers like the one we've researched on mental health.
So you mentioned that there are amendments coming, or there are recently adopted amendments.
The amendments haven't been crossed yet. The author's office is planning to cross the amendments in the second house, just due to deadlines in the first house.
Okay, and they address some of the concerns that Commissioner Ortiz had. Is that correct?
Yes, to the extent that we've described today, it's requiring reporting categories as opposed to describing the event in detail.
Okay, that's helpful, just to understand where we're at in the process. So given that it's a little bit up in the air as to what this is eventually going to be, again, I would prefer not to take a position today, but I'm just one member of the commission, so if anybody else wants to make a motion. Commissioner Baker?
Thank you. And once we have those pending amendments, we'll be able to put a cost on this, because I know that in your report, it's not clear what the cost would be for, having this in there. Obviously, they're going to have that as well. Is that correct? That wouldn't come until the next house, presumably, the next amendments?
Yes, we'll reevaluate the costs once we have the language in print.
Appreciate seeing those. Thank you.
Understand. What is it that you're looking for on this bill?
So what I'm looking for is how this disclosure is going to happen, whether it's going to be on a form
And that's one of the
460,
amendments.
right, or it's going to be in an addendum to the report. I want to look at the specific language to see how hard it's going to be for an attorney to construe it. Maybe we want to make changes to that. I also, as to Commissioner Baker's point, want to see how much it's going to cost the FPPC when we're dealing with a really tight budget. It is a completely new permissible expenditure. In the past, staff, if somebody asked them, can I use money to pay for my health insurance? No, right? But now staff is going to have to spend time advising on this, potentially adopting regulations that interpret some of the terms within this statute. Those are my concerns. I feel like we can flush them out, and we'll be particularly in a good spot to do that once we know what the, not necessarily final language, but ideal language from the sponsor.
And when do you think that we will get to that point in the legislative process, the next committee meeting? When do you think?
I don't know exactly when they're planning to cross the amendments. The deadline for passing bills in the first house is coming up, so it could be by the next meeting, but I don't know for sure.
So Nakano, just for clarification, the bill is on the Senate floor, is that correct?
Yes.
Okay, thank you.
Off the Senate floor?
And how did it do in Senate Elections Committee?
That bill.
Very well, if I remember correctly.
6-0. Yes. 6-0 with one member not voting, Senator Wen not voting.
Excellent. Thank you. Any motions from commissioners on this? Do we have any additional public comment I should ask first? Seeing and hearing none. Any motions from commissioners?
I am torn.
As she said, go ahead.
I don't know. I mean, here it is. My concerns are going to be dealt with, but I also hear what your concerns are. But I also want to support this, so that's what I'm asking about the timing. That when we could get to a point where we say yay or nay, kind of thing.
Commissioner Wilson.
For the benefit of Commissioner Ortiz, I think, at least since I've been on the commission, going back to 2019, when we've taken positions on bills, we've done it with a kind of unanimous consent among all five commissioners. So that's a factor to take into consideration. I can count, but I won't make a motion.
Okay. Okay. Why don't we move on to the next bills?
Okay, the next bills that we may have public comment on, I don't know for sure, but we may, are the bills that are amending, okay, we do have public comment, amending section 84308. There's 3 bills. These are at the end of the report. The bills are AB 2911 by Assemblymember McKinner, SB 1181 by Senator Glazer, and SB 1243 by Senator Dodd. So I'll start with AB 2911 by Assemblymember McKinner. This bill raises the contribution limit in section 84308 relating to when a public official needs to disqualify themselves because they've received a contribution from a party or participant. The bill raises the contribution limit from $250 to $1,500. The author stated that they would work with opposition, including Common Cause, on lowering the contribution limit potentially, but no amendments have been crossed at this point. And that bill is on the Assembly floor. And I'll go through all 3 bills, and then I think we can take comment after that, or we can go one by one.
That's perfect.
SB 1181, this bill adds a agenda notice requirement. That bill's on the Senate floor. SB 1243 by Senator Dodd. This bill was amended last week. There were a number of concerns that the Commission had about the bill, and the amendments do address some of them. The bill strikes the exemption for housing development projects that was added by a prior version of the bill. It adds a narrow exception for the periodic review of development agreements. It narrows the definition of when a matter is pending compared to the definition that is in regulation. In regulation, a matter is pending as it relates to an officer when the decision is before the official for their consideration, including when the item is placed on an agenda, or when the officer knows or has reason to know a proceeding is before the jurisdiction or agency for decision or action. The bill narrows that definition and provides that as it relates to an officer, a matter is pending only when it is placed on an agenda. This means that an officer could have actual knowledge of a future proceeding, receive a contribution over the limit, and not be held liable for receiving that contribution. The amendments also change the time period of the contribution limit to apply when a proceeding is pending and for 9 months following the date of the final decision. Compared to existing law, this bill shortens the post-decision contribution ban from 12 to 9 months after the date of the final decision. The bill also adds a new contribution prohibition for agents during the proceeding and for 9 months following the date of the final decision. As with any contribution prohibition, there are potential First Amendment concerns. I haven't gotten any information yet on the rationale for this change. The bill also retains the provision that provides that the contributions of agents shall not be aggregated with the contributions of the party or participants. It's not clear what this retaining that provision, what purpose that would serve, given that agents would be prohibited from contributing during that same period. And last, the bill adds a definition for agent. This definition is the same as what is in regulation. Overall, the amendments address some of staff's concern. They address the time period covered and the housing development project exception, but they also create new issues, specifically by narrowing the definition of pending and adding a contribution prohibition for agents. And that bill is also on the Senate floor.
Commissioners, anybody have a comment on this one? Ms. Nakano, are you able to give us an example of how this new, narrower definition of pending would act in practice? How would it impact this rule at the local level?
I think one of the best ones is considering the knowledge requirement. So if a officer has even actual knowledge that a proceeding will come before them in the future, but it hasn't been agendized, they can receive a contribution over the limit from the party, and they wouldn't be required to disclose it, and they wouldn't be held liable for receiving it. even if they had knowledge of it and knew that that proceeding was coming.
Okay. So if you had a city council member who's subject to this rule, you had an applicant who made a contribution to that city council member of over 250, which is the threshold right now, right? And then that applicant, after submitting the application, making that campaign contribution, tells the city council member that they have this application before another department in that city. Even if the city council member is not involved at all with making or participating in that decision related to that application, this $250 threshold violation is not going to apply. So he or she's not going to be in violation of 84-308 by accepting that campaign contribution under this pending, even though they know about it.
Correct.
Okay. My apologies if I made that even more confusing, but it's tough to come up with an example just because this is such a complex law, which is why I understand why there's so many different people, concerned about it. So I know we have public comment on this item. Is there any? Are there any commissioners that want to comment before we go ahead and do that? Doesn't look like we do. So go ahead with public comment.
Good afternoon. Can you hear me okay?
Yep.
Great. Thank you. Dylan Elliott. I'm calling in today on behalf of the San Francisco City Attorney's Office, David Chu. The Commission had discussed in its June meeting last year when adopting the SB 1439 regulations that the bill impacts elected city attorneys in a way different from other elected officials. We believe the law should be modified to recognize this distinction. City attorneys may be required to provide advice and therefore participate in any covered proceedings before the city. San Francisco issues tens of thousands of permits and contracts each year, if not more. Tracking the parties, participants, and agents for such proceedings where the city attorney isn't a decision maker is simply infeasible. Attorneys are bound by the rules of professional conduct and must act within the scope of these rules, and the same pay-to-play concerns do not exist. The law should be amended to provide that it does not apply to an elected city attorney's participation in proceedings in their role advising the city attorney's clients. We also strongly support other sensible amendments that will release compliance burdens, including raising the contribution limit as proposed in several of the pending bills, defining competitively bid contracts to include a contract subject to a competitive process rather than just a low bid contract, and excluding smaller value contracts under $1 million, imposing obligations on elected officials only when a party or participant or agent has disclosed their contributions, and limiting the requirements around aggregating contributions. Happy to share more if helpful. Thank you very much. Appreciate it.
Thank you. And have you shared these recommendations with the authors' offices of any of these three bills?
Yes, we have. It was not myself personally, but a representative of the city attorney actually testified in Senate elections on behalf of Senator Odd and SB 1243. And it is my understanding that there has been ongoing discussion with all three authors. However, and I hate to get out over my skis here for you all, but it is my belief that Senator Glazer's bill was held in committee today.
Okay. That's helpful. Has your office taken any positions on any of these bills?
Because the city attorney's office was representing themselves at the hearing for SB 1243, I believe a support position is an issue, though I don't have a letter in front of me and don't want to say that with certainty, but with them being there, I would say very likely yes.
Any other public comment? So I think we can move on from these bills and move on to the next bill.
I will start back up at the top of the report and go in order. Oh, okay. First bill is AB 1170. The bill was passed in the Assembly and is referred to the Senate Elections Committee and the Senate Judiciary Committee. AB 2001 by Assemblymember Gallagher. This bill passed in the Assembly last month and was referred to the Senate Elections Committee. AB 2631, this bill is on suspense, and I do not yet have information about whether it made it out today. The FPPC's costs include one IT position and the cost of the education software. SB 1027 by Senator Menjivar relating to redaction of bank account information on statements of organization. That bill passed last month in the Senate, and it is in the Assembly and was referred to the Assembly Elections and Judiciary Committee. SB 1404 by Senator Glazer relating to lobbying audits and a new lobbyist fee. Actually, have good news on this one. It made it out of appropriations today. Just got that news before this meeting. The costs for the commission include 6 to 7 positions in the audit division for the cost of the lobbying audit workload. And staff are determining whether there are ways to lower costs while also ensuring appropriate oversight and accountability. AB 2041. Oh, yes, please.
Thank you. On this is the Glazer bill, which will result in quite expense for FPPC. Does the bill have money, funding allocated for what he wants to do?
Yes, the bill includes a new lobbyist fee, and the fee covers a portion of the cost of the bill. There's about a $200 to $300 gap between what the fee would raise, the revenue the fee would raise, and what it would cost the commission. So that $200,000 to $300,000 would come from the general fund. Moving on to AB 2041 by Assemblymember Bonta, relating to the use of campaign funds for security expenses. The bill passed in the Assembly 72-0 and is in the Senate and was referred to the Senate Elections Committee. AB 2573 by Assemblymember Mike Fong. This relates to the services of a fellow and whether those are considered a gift under the Political Reform Act. That bill was amended earlier this month. The bill was broadened to provide that the services of a fellow provided by a 501c3 nonprofit to a state agency for the purposes of assisting with official state business, a state agency business, do not constitute a gift under the Political Reform Act. There's a question in the Law and Policy Committee about whether this could potentially be abused. On that point, the bill amends other areas of law for the same purpose, including the Legislative Code of Ethics and the State Civil Services Act. And as part of those amendments, the bill provides that the services of a fellow are not considered a gift or compensation to the official, so long as the services are duly authorized in an executed memorandum of understanding between the nonprofit and the agency. The MOU is required to include certain elements, including selection criteria and an agreement that the fellow will comply with the relevant codes of conduct and disclosure requirements. Staff are recommending that the bill be amended further to add that the MOU requirement, or to add that MOU requirement to the section amending the PRA to help ensure that the fellow is provided as part of a legitimate fellowship program. AB 2803, Assemblymember Valencia, relating to the use of campaign funds for a comment?
No, I have a question about this bill.
Oh, okay. Thank you.
Go ahead, Mr. Goddard.
It's relating to the use of campaign funds for legal defense for criminal convictions. That bill is on the Assembly floor and was ordered to the consent calendar.
Okay, thank you. An elected official can still create a legal defense committee, and that will be okay, correct?
Yes.
Okay. And then the other part is, it says prohibition with criminal litigation. If the litigation results in a conviction, you cannot pay the attorney fees with that. But what happens until that point, whether the person is found guilty or not? And that person has an attorney. Are those expenses that elected official start making, acquiring from until that decision? What happened to that?
Good question. It's a timing issue, but I think practically how that works is they would be allowed to open the legal defense committee and expend funds, but once there is a conviction, they would have to reimburse the committee using personal funds.
Okay.
Moving on to AB 2990, relating to FPPC enforcement actions and time limits. This is Assembly Member Lowe's bill. And let me check. I actually think I did get an update on that. That bill was held in committee, in the Appropriations Committee, so that bill will not be moving forward. AB 3239, Assemblymember Carrillo, relating to the use of campaign funds for emotional support animals in airline travel. That bill is on the Assembly floor. In the Assembly Elections Committee, the author cited research on the health and therapeutic benefits of emotional support animals and stated that in 2020, the United States Department of Transportation announced that it was revising the Air Carrier Access Act relating to the transportation of service animals by air. I looked more into that change, and as relevant here, one of the changes was that emotional support animals are no longer considered service animals, which are allowed to fly for free. To be a service animal, the animal must be a dog that is individually trained to do work or perform tasks for the benefit of a person with a disability. And as a result, emotional support animals, individuals now have to pay to fly their own emotional support animals. I think there's a question about the impetus for this bill in the law and policy meeting and possibly in the commission meeting last month.
Question on that one. So since we have that distinction, I believe for service animals, there are criteria for getting a license for being a service animal. Is there something similar for emotional support animals? Is there some sort of governmental oversight that the authors pointed to?
They do cite a definition in the Health and Safety Code. However, in that definition, there is no registration or certification required for the emotional support animal.
Okay. So similar to the other bill that we were discussing earlier related to medical health expenses. If FTB was conducting an audit, how would they determine whether an animal, a dog, was in fact an emotional support animal?
I'm not aware that there would be any documentation that they could refer to. I don't know if people get doctor's notes or other medical certification. There's nothing required, so it would be kind of the self-certification of the candidate.
Okay. And often these audits happen years after the expenditures. So with no record-keeping requirements, right, that I'm aware of, it may be difficult to verify whether this is actually the case, whether they actually meet this criteria. So that's one concern I have with this specific bill. Any other comments from commissioners? Okay. Public comment on this one? Hearing and seeing none, we can move ahead to the next bill.
Okay, SB 948 by Senator Limon. This relates to the transfer of campaign funds. That bill passed in the Senate 37-0 and is in the Assembly awaiting referral. SB 1111 by Senator Min. Oh, yes.
Haven't we been discussing this, SB 948? And so why are we taking no position?
That's certainly within the commission's
Okay, so we
option.
haven't decided whether, because we have been lots of time we have been talking about this.
We have, and I believe I don't know if we actually adopted a motion, but the last decision we made was to table our discussion on a regulation.
That's right.
Until after, I think until September or until
Okay.
this is.
Yeah. Thank you for refreshing my memory.
Of course. Is that correct, Ms.
They were not sure.
Yeah.
I think that's correct. The commission had been considering a regulation project that was put on hold because of this legislation. So depending on what happens with the legislation, the commission might want to reevaluate a regulation project. However, if the commission wishes, it's free to take a position on this bill at any time.
Or comment on that one? Okay, public comment? Hearing and seeing none, we can go ahead or you can continue with your discussion of this bill.
For SB 948, that's all I had, but moving on to SB 1111 by Senator Min. This bill is on suspense, and I was brought over here before that bill was brought up, so I don't have an update on that one at this time. SB 1151 by Senator Hurtado, relating to registration and reporting requirements for foreign agents. That bill's also on suspense. No update on that one yet. The costs included one position in the legal division and one position in the enforcement division. Both SB 1155 relating to a post-government employment restriction for former heads of state administrative agencies and SB 1156 relating to financial disclosures for groundwater sustainability agencies. Both of those bills are on the Senate floor. SB 1422 by Senator Allen. It was heard in the Appropriations Committee today. That bill was held in committee and will not be moving forward this year. SB 1476 by Senator Blake Spear relating to the State Bar of California passed in the Senate 37-0. It is in the Assembly awaiting referral. Let me check if I've gotten any additional updates. On AB 2631 by Assemblymember Fong relating to the education ethics training program for local officials, that bill passed in the Assembly Appropriations Committee with an amendment to strike the appropriations contingency. So I'll look more into what that amendment looks like. I haven't seen the language yet, but I'll keep the commission updated.
And I know Commissioner Baker had to leave early, so I'm going to try to step into her shoes. I know she had some questions about the 84308 bills that we already went over. One of them was whether Senator Glazer was considering any amendments to his bills. Are we aware of any amendments that he's considering introducing?
Senator Glazer's office is considering amendments. I don't know that they've finalized what they will move forward with or when they plan to amend. At this point, it looks like if they amend, it will be in the second house.
Okay. That's helpful. Any other commissioner comment? Public comment? Okay. Hearing and seeing none, I think we can let you go back to your office and get back to that suspense file.
Thank you.
Thank you, Ms. Nakano. Oh, Commissioner Wilson.
I just want to commend Councilman Nakano on the excellent outline of what the suspense file is in the Senate and the Assembly. And for the benefit of the public, that's reflected in the minutes from our last meeting that were posted today. So I know a lot of people think they know what the suspense file is, but you did a great job explaining how it works between each house.
Very.
On to our next item, which is going to be executive staff reports, and we'll start with the Enforcement Division. Welcome back.
Just one item that I wanted to bring up from the Enforcement Division report, and that is one of the streamlined matters that is in the report of case number 24326. We are actually pulling that matter, and that stipulation will not be signed. We received there was a rescission of that agreement that put it on the agenda. We looked at some additional information that was provided, and we've actually agreed to close that matter with a warning letter based upon that additional information.
Repeat the case number?
Yeah, it's 24326. The Thompson matter. So it was a one count tier 1 streamlined penalty that we are taking off.
Thank you. Mr. Bainbridge, do we have to make a motion to remove an item from Streamline?
Those are informational, so I think he's just providing that information that it'll be removed. I don't believe a motion is necessary.
Excellent. Commissioners, any comments? We have public comment on the Enforcement Division agenda. Okay. Hearing and seeing none, we could move on to the next executive staff report, and that's going to be the Audits Division. Chief Shah, welcome.
Hello. My report is as submitted. However, there is a part about lobbying audits that I would like to provide a brief update on.
Excellent. Yeah, we'd appreciate that. And I'm glad you're here to talk about that because as you're going to expand upon, the FPPC conducted a discretionary audit of several different lobbying entities. I believe we did 5 discretionary audits. There's still one that has not been completed. And of those 5 audits, we found material violations in 4 of them. And in one of those discretionary audits, we found that there was an individual who was lobbying without being registered as a lobbyist for over a month, which is a pretty significant violation. But I'll let you go in further depth as to what you found.
Yeah, so as part of our pilot program, we selected 6 lobbying audits. 3 of them were the lobbying firms and 3 were lobbyist employers. And these audits were done as part of our discretionary audits conducted under 90,003 of the Political Reform Act. The goal was to find out or actually perform an analysis of the lobbying filing requirements, get a better understanding of the workload that was required for lobbying audits, and then to see what the level of compliance was in the area of lobby filings. So, as you mentioned, 5 of the 6 audits have been completed. We have 1 in process that we have a target completion date of July 2024. So it's almost to the point of getting done. Through these audits, we noted a large degree of non-compliance. 4 of the 5 audits, like you said, have findings. And the findings, as mentioned in our exec staff report, we have generalized them into 4 categories. The first one being lobbying statements, reports not filed or not filed timely, or not filed in paper and electronic format. This includes, but is not limited to, the lobbying firm registration statement, which is Form 601, the amendments to the registration statement, which is the Form 605, and several other filings that were either not filed at all or filed late. And these are all required to be filed electronically and in paper. So there was a combination of either late filing, not filed in one format and filed in the other, or just filed late in both formats.
Who's not familiar with actually goes, what is disclosed in these reports? So what sort of activity, payments, et cetera, are disclosed in the lobbying reports? My understanding, they would have to disclose what bills they're lobbying on, in some cases what agencies they're
Yes.
lobbying, what sorts of gifts they're providing to public officials, and campaign contributions as
Yes,
well to
any
public
activities
officials.
related to their lobbying activities.
Right. So if they're delayed, there is a public harm. The public does not know who these organizations are lobbying and who they're seeking to influence through gifts, activity expenses, etc.
The second category of finding we found was lobbying prior to registering, which means there were lobbyists out there who were already lobbying, but they had not filed their proper forms that were required to, under the Act. So Forms 603 and 604 are required to be filed timely in paper and electronic format within 10 days when adding or deleting a lobbyist, or for renewal of lobbying certification by completion of ethics orientation course. We found that in one audit, the Form 604 was filed 29 days late in both paper and electronic format, and in another, it was filed 80 days late in paper and 79 days late in electronic format. There were multiple other instances where the 603 and 604 forms were not filed timely. Basically, this means, like I said, that the lobbyists began lobbying prior to registering and completing their registration requirements, which are required under the PRA. The third category was misreporting of payments received for or expense reimbursements received. So in one of the 4 audits, we noted that the payments received by the lobbying firms were overstated by a total of $20,000 for 4 months, and expense reimbursements received by the lobbying firm were overstated by $25,000 on the lobbying firm Form 625. The last category of finding was over and underreporting of activity expenses, and we found out that the lobbyist employer Form 635 underreported a total amount of an activity for one lobbying audit. We also ran into a lot of challenges and issues while doing these audits. One was the absence of detailed timesheets and dated supporting documentation. This prevented auditors from verifying time spent in reportable lobbying activities as opposed to the time spent on non-reportable lobbying activities. So we kind of had to guess based on the information that was provided whether it is directly related to lobbying activities or it's not. And there was no way to verify if it was or wasn't. And there is a lack of requirements for specific documentation for allocation amounts reported on the lobbying reports. which results in receiving information and documentation that kind of supports the explanation for activities, but it lacks the details. So, like I said earlier, it makes it very difficult for the auditor to go back and forth, and then we have to keep reaching out to the lobbyists or the lobbying firms to get information on, hey, we see ABC expense reported, is it related to lobbying? And basically there is no supporting documentation required by them to be filed. So there was no way of verifying most of these.
On that point, how long did it take us, if you can disclose this information, from the start of our audit effort and these individual audits to finish? How long did it take us to conduct each audit?
It took around, we have 190 hours, an average of about 190 hours, which was spread over about 2 years.
And the requirement under law right now for lobbying audits, which are typically done by franchise tax board, right, is that 25% of, I believe, lobbying firms and lobbyist employers are audited each legislative session. Is that right?
That is correct.
And these audits, I don't believe, when was the last time that franchise tax board completed an audit for a session? I should say, what was the last legislative session that FTB completed an audit in?
They completed 4 from the 2021 draw that we did.
Okay.
And they have 1 in process as of right now with a completion date of January 2025. And this is from last year's draw, from the February 2023 draw. And that's all we have for multiple years.
And then prior to that, we're looking at the 2015, 2016 session?
Yes, I do have that information. I can quickly look at that.
Okay. Sure. Yeah, so I guess what I'm getting at is we're talking about over 1,000 audits that should have been completed. We're looking at less than 10 that were completed. 25% of lobbying entities are audited every legislative session. So there's hundreds of lobbying entities that lobby actively at the state level that there's essentially no oversight as to whether they're disclosing the correct information. And we conducted this discretionary audit, which showed that 4 out of the 5 lobbying entities that we chose essentially at random had violations. That's pretty significant in my opinion. I'll go to Commissioner Ortiz.
Thank you. These audits, that found lobbyists not registered, are they solo lobbyists or do they work for a lobbying firm?
I believe the one that we found, they work for a lobbying firm.
They work for a lobbying firm, so I'm not trying to chuckle, but what does the lobbying firm allow to have a lobbyist who is not registered? Who's the responsibility? The lobbying firm or the specific lobbyist to register?
I believe it's both. It is the lobbying firm's responsibility to make sure their lobbyists are registered, and the lobbyists are responsible for providing their certification if they have completed it to show that they are qualified as lobbyists.
And just one clarification there. So a contract lobbyist is a lobbying firm themselves. So they're both.
So it's a solo.
Right. So I don't know if that was the case here. I think it was.
Yeah.
So
Okay.
they would be subject to
So
both those
how did you
requirements.
find that lobbyist who had not registered in order to audit him or her?
When we audit them, we look at all of their filings, and we get a list of lobbyists who are registered with the firm, and we go back and match their filings to the lobbyists to see if they were filed on time, and if they were filed in both formats.
So this person eventually registered. They were lobbying
Okay,
roughly
so-
a month
Yes,
without
they did
registering.
register late.
Okay, so
Yeah.
we're looking, okay.
Correct.
I find it interesting that a lobbying firm will not request their employees to
Yeah.
register.
It's true. It's very surprising. There's a lot of surprising aspects of this. You got 4 out of 5 with material violations, lots of other things, but I'll throw it over to Commissioner Wilson.
Woodher may have had her hand up before me. So.
This is brief, but just because you just mentioned it again, when the FEC did random audits of candidates back in this or mid 70s, over half of the randomly selected campaigns had violations. And so I think compliance is actually pretty tricky, though of course lobbyists should register. So there's a kind of a spectrum of violations or whatever. But the 80% violation rate, right, the 4 out of 5 is higher than what we found when we studied it. But these are kind of complicated compliance matters sometimes. And so I just wanted to kind of add to the conversation in that way.
Chief Shaw, given the backlog of cases, I think that's an understatement, I commend your division on addressing these issues. What is the statute of limitations, if there's one that's applicable?
I believe it's 2 years from the date of the draw. that the
Oh,
audits
it's
have
based
been.
on
So
the
we
draw.
cannot go back and audit from a prior draw. We have to move on.
But it's based on the draw, okay.
Yes.
Thank you.
Just to clarify, that's the amount of time that FTB is asked to complete the audits by. However, violations that are found as part of an audit, they're still subject to the typical 5-year statute of limitations unless there is intent to conceal. Is that correct? Okay. So I'm seeing a lot of nodding over here. So I'm assuming that is correct. So there is that distinction there. So I guess a good question would be, so we have outstanding audits from the 2017-2018 session. So if it was activity in 2017, I'm trying to do math really quickly here. I think that's beyond 5 years. So if FTB completed it tomorrow, their audit found significant violations, we wouldn't be able to go ahead and prosecute. Is that correct? I guess I'll throw that to Chief Lindsay. Okay. Chief Lindsay confirmed, yes, that is correct. So just another reason why this is a significant issue. And why we're so in support of SB 1404, which we've already taken a position of support on. So any other commissioner comment on this item? Okay, any public comment on this item? Okay. Hearing and seeing none, why don't we move on to the legal division report? General Counsel Bainbridge.
I would just point you to page 13 under letter H. This is in the report every month. You may not pay much attention to it, but given that we discussed conflict of interest codes and the adoption of them today, we list all of the codes since the last meeting that we as the code reviewing body have approved. So that's why that's there. And just as Suki mentioned, we have over 900 agencies for which we are the code reviewing body. And I think we have 4 full-time and 1 part-time staff member who works on those, and it's not even their full job. They also give email advice. So it's quite a workload, and they do a great job of handling those.
Commissioner comment on that? Any public comment? Hearing and seeing none, why don't we move on to Administration and Technology Division? Acting Chief Wang.
Chair and the commissioners, I will submit the report as it is and happy to answer all the questions you have.
Excellent, thank you. I know we have, your report indicates we have 1 outstanding 87-200 filer.
Correct.
It sounds like we've been in contact with their agency, and they're going to do their best to get this person to file by our next meeting.
Right. So we try contact to the contact over there. So they are trying getting holder of this filer. So we try to verify all the information before we plan to send referral to the enforcement by the end of this month. But before that, we will try to verify all the possibility and try to get a hold of the filer.
Okay, thank you. That's helpful. And I know we do injunctions in the campaign context to force people to file campaign reports. So I think the filer should consider that may be something that we would pursue in this context as well.
Right, that's correct.
Thank you. Any other commissioner comment? Okay, let's move on to the executive director update.
Hello. So I'm going to punt to our communications director, who's going to give you an update on our 50th anniversary planning.
Good morning, Chair Silver and Commissioners. Jay Wieringa, Communications Director. As you know, 2024 marks the 50th anniversary of the passage of Prop 9. and the Political Reform Act and the creation of the FPPC. And I've been tasked with coordinating the planning of an event to commemorate this occasion. So we are planning to have an event in the fall in September on Wednesday the 11th. And this time and date was chosen because we are partnering with McGeorge School of Law from the University of Pacific and the Capital Center for Law and Policy. They have graciously donated event space for us at that time and cooperation with things such as marketing and outreach. We all agreed, who were part of these meetings, that this was a time that is not right up against the election clock where we are very busy, our staff is very busy, but it's after the summer and Labor Day holiday breaks. So it'll be in the middle of the election season, so we hope it will garner a lot of attention, especially from the media. People's attention will be focused on the election at that time. We plan to have an event that features panel discussions, panelists, moderators, speakers, focusing on the past, present, and future of political reform in California. So we are in the process of formulating these panels, their makeup, the moderators, the scheduling. We also plan to have a keynote address from someone we hope with significant experience, ties, and influence in the realm of political reform, campaign finance, and ethics. I have made contacts with representatives of one such person, but we'll have to wait to make any announcements until we get some confirmation moving forward. The day hopefully will also include some light snacks, refreshments, maybe a luncheon or a boxed lunch, and hopefully an open house here at FPPC headquarters afterwards. Cole Smith and Sasha and others are assisting me in this endeavor. We are coordinating together with the chair, the executive director, the good folks at McGeorge, and we'll have more information about this as it becomes available and things get confirmed. With that, I'll answer any questions.
Any questions from commissioners? Any public comment? Hearing and seeing none, I think we're going to move on to item number 10, commissioner comments and proposed future agenda items. I know Commissioner Baker was hoping to discuss the advisory letter that we had public comment on earlier under item 1 at the next meeting. Do we have to take any sort of motion to bring that back?
The commission doesn't have to take a motion. That's at your discretion of what to put on the agenda.
Okay, excellent. Any other comments? Any public comment? Okay, hearing and seeing none, I'm going to move to adjourn.
I'll second.
Commissioner Ortiz?
Yes.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Silver?
Aye.
The motion passes.
Thank you.
Thank you.